Section 230 is the most important law protecting internet speech. And removing Section 230 will remove speech from the internet.
Some say that ending 230 would solve all of the internet's problems.
We have to get rid of Section 230 or you're not going to have a country very long.
And we need to consider reforms to Section 230.
Section 230. This is the shield big tech uses to eliminate content they don't like.
There's more that needs to be done in reforming Section 230.
My executive order calls for new regulations under Section 230 of the Communications Decency Act.
Section 230 of the Communications Decency Act.
Section 230, Section 230.
Section 230.
Section 230.
Section 230C1 of the Communications Decency Act is often referred to as the 26 words that created the internet. This section in question states, no provider or user of an interactive computer service shall be treated as the publisher or speaker of any information provided by another information content provider. This seemingly innocuous phrase means that online service providers that host user-generated content such as Twitter, Facebook, or YouTube have broad immunity from liability for things such as defamation arising from content posted by their users. This is a lot different than the typical common law case of print media, where a newspaper would be strictly liable for any defamatory articles it chooses to publish or republish, even if the articles were written by a third party. So why does this unique immunity exist for online republishers of content like Twitter? In order to answer this question, we have to look to the state of internet liability prior to the enactment of Section 230. When the internet was first getting off the ground, online service providers were only insulated from liability from posting third-party content on their websites if they took a hands-off approach and acted merely as passive distributors of third-party content. This protection from liability, however, did not extend to a platform that moderated user-created content or otherwise engaged in editorializing. The common law took the approach that once an online service provider started to moderate content, they were acting as publishers rather than passive distributors of content, with the former being subject to a more stringent standard of republication liability. For example, think of a defamatory article republished in the New York Times versus a bookstore selling books that might have some defamatory material. Under most state laws of defamation for print media, the newspaper would be strictly liable for defamation regardless of whether they knew the article was defamatory, while the bookstore likely would only be liable if there was a showing of fault, such as that a bookstore actually knew of the particular defamatory content being sold. This method of determining liability when applied to online providers created a perverse incentive to not moderate content at all, as any attempt at editing, curating, or deleting content, or otherwise enforcing rules of civil behavior on a platform would automatically expose the platform to increased liability and risk by making that platform a publisher rather than a distributor. Section 230 was created to reverse the incentives and allow online service providers to moderate their content without losing their liability shield, and allows providers to engage in traditional editorial functions, which include decisions about how and whether to publish, organize, display, promote, suggest, or remove third-party content. And thus, the internet was saved because of Section 230.
Let's go get some more snacks.
All right.
After Section 230, companies had more of an incentive to actively build and curate large user networks where users could post their created content without having to constantly be faced with spam, pornography, hate, or violence. Zanga, MySpace, Newgrounds, Facebook, Tumblr, Instagram, YouTube, Twitter, and many other popular websites would likely never have existed without this essential law.
America Online can do all that?
Yeah. How about sending your mom some nice flowers? All you do is click on Marketplace, we place an order.
Call now for America Online, a new way to use your computer.
Thanks to Section 230, companies that host trillions of messages are now shielded from being sued by anyone who is wronged by something someone else has posted online, while being able to moderate their content to enforce their own standards, beliefs, and even political or company biases. However, in the years since the enactment of Section 230, service provider immunity has seemingly continued to expand, with no real limit to the immunity in sight. The law has drawn criticism from both sides of the political aisle.
We've seen some really egregious behavior by these two social media platforms, Facebook and Twitter. They say we're politically neutral. We don't tip the political scales. But what they can't do is to do that, and then number two, go on and do something completely different.
And I think now you see a bipartisan recognition in Washington and even around the country that these are increasingly the platforms where public discourse is held, and we have no insight into who's allowed to speak and when and why.
It is clear that tech companies have changed dramatically over the last 20 years, and we need to consider reforms to Section 230 to account for those changes.
I will say it's dismaying listening to the questions from our Democratic colleagues, because consistently the message from Senate Democrats is for Facebook and Twitter and Google to censor more.
The big ongoing question is, at what point does an internet service provider exceed the scope of traditional editorial functions and instead become a speaker themselves? A speaker that should be held to the same liability as every online user.
On January 24th, Apple Computer will introduce Macintosh. And you'll see why 1984 won't be.
Which brings us to the Supreme Court case of Gonzalez versus Google, LLC, which was just granted certiorari, which means that the Supreme Court has agreed to hear the case, which is somewhat surprising given that the Supreme Court has traditionally rejected to hear cases regarding Section 230 for one reason or another. Gonzalez versus Google, LLC asks a narrow but important question of whether internet service providers, such as Google, exceed the scope of traditional editorial functions by recommending content to users via their unique algorithms, and therefore whether they can be held liable for recommending certain content. The case of Gonzalez vs. Google arises out of tragic circumstances. The family of Nohemi Gonzalez sued Google under the Anti-Terrorism Act, alleging that by recommending ISIS recruitment videos on YouTube through its YouTube algorithm, Google, as the owner of YouTube, could be held accountable for Nohemi's death during an ISIS attack in Paris in November 2015.
23-year-old Nohemi Gonzalez was killed in these attacks last night. She was out having dinner with her other friends who were studying abroad here, like so many do on a Friday night. ISIS claims to have carried out the coordinated 6 attacks.
The plaintiffs argue that the algorithmic recommendations that companies such as Google use to retain users' attention and increase the time that people spend on their websites go beyond traditional editorial functions and therefore go beyond Section 230 immunity. One argument raised by Gonzalez is that recommendation of content isn't the same as traditional online republication of content, such as every time YouTube allows a user to post a video. This would be covered by Section 230 immunity. The argument is that recommendation is rather a separate and independent form of speech, a form of speech being made by YouTube itself and not by its users. Here's a brief excerpt from the Gonzalez brief. Suppose, for example, that YouTube were to recommend content that was available on only the website of a different social media company, such as by writing and posting on YouTube a glowing review of an ISIS video on Vimeo. The review would not constitute itself publishing the ISIS video that's available on Vimeo. That YouTube prepared recommendation would not turn into publication of the video if, after the review has been distributed to YouTube users, ISIS also posted that same video in question on YouTube itself. Recommending things like books or TV shows is not an inherently publisher function covered by Section 230, because although only whoever prints a book is its publisher, anyone can recommend a book. The argument goes on to say recommendations are in essence communications by the online service provider to its audience rather than communications from a third party, and thus should be considered a form of first-hand speech, subject to liability, just like anything you might yourself tweet or comment, rather than as protected publications under Section 230. Gonzalez's argument can thus be summarized as proposing that the protections of Section 230 are limited to a publisher's traditional editorial functions, such as whether to publish, withdraw, postpone, or alter content provided by another, and do not additionally include recommending writings or videos to others through algorithms or otherwise. Google's counterarguments are that, unlike traditional reviews or recommendations, its recommendations are based primarily on user inputs. So in other words, they're already basically doing the same thing as a search engine. Take the following excerpt. YouTube does not produce its own reviews of books or videos or tell users that a given video is quote-unquote terrific. What petitioners challenge is YouTube's display of content responsive to user inputs. The internet version of a newspaper putting a story of interest to international readers on the cover of the international edition, or a book publisher offering 3 popular mystery novels together as one bundle. Section 230 protects these quintessential paper and ink publisher activities in the internet context. Pairing one third-party video with another based on the user's activity does not change the underlying content. Search engines, like features that display recommended content, are implemented through automated algorithms which select the specific material to be recommended to a particular user based on information about that user that is known to the interactive computer service. However, there could be somewhat of a flaw in Google's argument if it would be discovered that Google might not recommend certain videos despite a user's search terms because the algorithm was written in a way to reflect the company's beliefs, policies, or interests rather than the user's needs or wants. Now, I don't know if this is the case, and at this point this is pure speculation based on anecdotal information at best, but if this was the case, Google might indirectly be saying this video is terrific because we're recommending it over all the other ones that you actually want to see. Or it might be saying another video is so horrible that you won't even get it recommended despite searching for it hundreds of times, based entirely on Google's subjective policies rather than your user inputs. Take this statement from a brief to this case from the Liberty Justice Center. Often the algorithm acts at the intersection of what the consumer wants and what the platform wants. In other words, the algorithm may push content the consumer will be interested in, but from which the platform receives ad revenue. If a consumer is interested in running shoes, the platform algorithm does not necessarily treat Nike and Adidas equally. It pushes more content for whichever company buys more ads. If this is true, it would go against the argued intent of Section 230, which was to give internet users more control over the content they see online, or in simple terms, to be free from being spammed with pornography and hateful content every time they go on the internet. It's still very, very early in this case to say what the outcome may be or what new arguments might develop as more people submit briefs to the court. But it is possible that this case could result in a world where you are never again recommended a video of something like a cute puppy on YouTube completely out of the blue. It's even possible the recommendation algorithm that's so prevalent in all these big social media companies might not exist, and instead you will only see videos of creators you've subscribed to or the tweets of the people you follow. It may well take over a year for us to get a final decision on this matter, as an official hearing date hasn't been set yet, but I would keep my eye open and keep an eye on this case, as it may change the internet forever.